Good afternoon, everyone. Thank you for joining the webinar on emerging challenges to consensus and coherence in business and human rights in East Africa. And we are going to start the webinar right now. And first and foremost, I would like to thank everyone for joining and send our sincere gratitude to ELS Secretariat and the BHR Committee for organizing this webinar. As indicated with the title itself, we are going to discuss the consensus and coherence in BHR in East Africa. And looking at the East African region as a whole, most of its partner states are rich in different natural resources, which attract significant attention on issues of extractive industries and also energy sectors, where one of the things that most of the countries are promoting is on investment and trade. We're looking at investment and trade, it links to different challenges such as discrimination, labor issues, land issues, all that are associated with promotion of investment and trade within this region. Whereas at the same time, while we are promoting this and the risks associated, the communities are the ones facing the challenges of receiving the significant impact of all these associations. And when we look at the EAC as a whole, our state leaders have taken different initiatives in picking up the issues of business and human rights agenda. And two of our country regions, that is Kenya and Uganda, have taken the first step in adapting the National Action Plan on Business and Human Rights, though other partner states such as Tanzania have also shown an intention to move in that similar track or similar direction. So with this webinar, we aim at discussing all the best practices associated in the region that cooperation has implemented, but also looking at the challenges and what states has done towards implementing a business and human rights agenda in the countries and existing remedies that victims can use to ensure that they get the redress. And our webinar will have 4 panelists, that is Dr. Jessica Mhonja, Ms. Linda Banja, Mr. Joseph Biomuhagia, and Ms. Joyce Komanya. And we'll start our webinar with our first speaker, who is Dr. Jessica Mhonja, and who is the CEO of Com Group of Companies. And she will take us through how the business sectors, the corporation, have integrated and are considering issues of human rights in their daily activities, and that through that discussion, we'll be able to get the best practices and initiatives that have been implemented throughout. Welcome, Dr. Jessica.
Thank you very much, Grace. As introduced, my name is Dr. Jessica, and I'll be taking you through the best practices that a business can promote. They are following the right human rights. So to start, I would first define what general business practices in business mean. And this means that this covers the entire aspect of a business being responsible in its entire supply chain and the impact it's creating in the various community where it's operating. Now, there are various ways to go about it, whereas setting up a business itself requires the respective business to have regulations. So it requires the business itself to follow the general rules and regulations that are set up by a specific country. And now this would include having the right business permits, having the right business setups, and adhering to really the rules and regulations that have been set forth. Now, another aspect of it having a the best business practices is by engaging stakeholders in various projects that are coming in order to assess the impact that the business might have on the entire society, the environment as well, and how this would affect then the operations of the business, but the society in which it operates both positively and negatively, and then sort of try to mitigate these risks. Another common practice is to conduct due diligence in terms of the entire supply chain and ensure that all the suppliers or all the stakeholders that are involved in this entire supply chain really comply to the rules, regulations, values that a business has. Now, when we are talking of safeguarding human rights or integrating these human rights in the business itself, and I'll look at it in other angles, such as employment angle, as well as the environmental angle. So touching on the employment angle, the best practices would be now having recruitment policies in place that ensure that everybody is treated equally. All job seekers follow the same procedure in order for them to get a job, be employed. But whereas after they receive employment, then it becomes the responsibility of the employer to ensure that labor laws and rules are really followed, and that the employees themselves get additional benefits. You have your health benefits, you have your other housing benefits, but also career advancement benefits. You have your the leave benefits. So businesses must be able to adapt these practices to ensure that they are safeguarding really human rights. And also we know that in all organizations, issues such as grievances can occur from time to time. So the way the business handles these grievances is also quite important to ensure that people are really safeguarded. With this in mind, businesses can have whistleblowing policies to ensure that in case something is not going right, then the right stakeholders get the right information and right procedures are followed. Now, in terms of the environmental aspect of it, so this would involve the nature of the business. Previously, I touched on engaging stakeholders before you start a particular project. Now, we've seen issues in sectors, particularly manufacturing sectors, but also the mining sectors, whereas you find out that maybe businesses somehow fail sometimes to really adhere to the right rules and regulations, where you find out maybe there are small miners in a particular place, and all of a sudden they are supposed to leave the place to leave room for the investor without having really right compensations. So better practice would be being able to engage these stakeholders way in advance, compensate the local community, and then continue with business activities. And now talking of the industrial sector itself, nowadays, sustainability has become quite important, and how the business is able to operate, conduct its activities as well. So this would involve having a review of the type of emissions that manufacturing industries cause, and having measures in place to reduce such emissions to ensure that this environment is safeguarding, as we are seeing an increase of climate issues in the region are highly affecting and impacting local communities. So yeah, with this in mind, these are some of the best practices that businesses can follow or should be following to ensure that they are safeguarding human rights, whereas they are also continuing with their daily operations. Over to you, Praise.
Implementing that human welcome is will now so sorry for that. So as I was saying, I welcome Ms. Linda Banja to take us through the existing challenges arising from trade and investment where corporations are not implementing the best practice in their activities. Welcome, Ms. Linda.
Thank you, Praise. Good evening, everybody. My name is Linda Banja. I'll be taking you through the challenges, the existing challenges that are arising from trade and investment in East Africa propagating human resource violations. We know that within the East African community, in which development within the economies. The extractive industry plays a key role in the East African communities. Entail by use of oils, metals, use fossil fuels, fishing, hunting, and also basically includes fish. What are the challenges that the environment that most state parties but for investment, why we are
Ms. Banja, maybe you could switch off your video. We can hardly hear you.
okay. I've adjusted the volume. Is that better?
No, the internet, I think it's a bit shaking. So maybe you can switch off the video to give it the bandwidth.
Okay. That is my phone. So I've gone a bit closer. I hope that will be much better. So the political environment is a key element when you're considering a country where you're going to invest in. So for instance, countries that are landlocked, but also lack the political stability, fail to provide the environment that is requisite for growth and investment and trade to take place. Why? you cannot invest in a place where you're not sure that the security in terms of the investment you're putting in, the capital investment you're putting into, the human resource investment that you're putting in that place. If you're not satisfied that the amount of investment that you're setting in is secured, then definitely you will not be putting in any kind of resources to that end. Secondly, we have issues on the tax environment. I'll still use the example of Kenya. Right now, basically, I'm talking with a disclaimer on it. This is my opinion. There's been a lot of shift with many of the multinational companies, quite some number leaving. Why? Because the tax environment is extremely high. For any investment, any resourceful or positive investment to be taking place, there has to be an environment that is conducive financially for any amount of trade and investment to take place. So you find there's a shift mainly to the West African countries. Why? Because there are incentives that are given, there are rebates, there are certain exemptions that are given in terms of taxation. So that provides a conducive environment for the development of trade and investment. Thirdly, there's the issue of physical policies that are implemented by the state parties. What kind of physical, in terms of monetary, in terms of regulations, statutory and otherwise, that are in place within those particular countries, are they feasible enough to provide room for stable growth and stable growth and development of just not companies, but also individuals within those places? So a lack of that also acts as a hindrance to development of trade and investment. My other key focus I'll be focusing on was the issue of the extractive industry. Basically, what are the challenges? It was a question. What are the environmental challenges that are arising from different businesses, sectors such as extractive sector and the gender disparity in trade and investment? So my focus on this also will be on the issue of extraction industry, where I had first discussed about the focus on the extractive industry, not just on mining and oil, but also on derivatives. Those are rocks, minerals, fishing, deforestation, and all that. So what is the impact of the extractive industry on the environment? First, I'll look at the negative impact, because that's where we look at what are the things that, first of all, impact on the immediate environment where these extractive industries take place. There's a contribution to the air, there's a contribution to the water, there's a contribution to the land pollution, toxic waste, and water pollution. So what is the impact on the environment of the extraction process? So the first thing that we look at, because we look at the raw material that is used within this segment, there's the extraction process, there's what is derived, and the final product, what is the impact on that? So there's a first impact, first contact point, which is the soil, where all these extractions are made. There's the aspect of soil degradation. In terms of fishing, there's an aspect of water shortages that are experienced. There's an impact on the biodiversity. What impact does it have on the animal or the creatures that are within that particular environment? There's the damage to ecosystem functions and the aspect of which has largely contributed to the climate change that we're experiencing. So there's an aspect also that extraction units. Fuel non-productive populace within those. Also, where there income generation, there's aspect of prostitution. That was done. Have reported that they are in this abuse was as a result of the interaction they had with when they were going to extract these minerals themselves physically or indirect in services. Then there's the aspect as well of corporate engagement. Borders how does the extractive industry impact on the aspect of gender? There's not much development that has been done on the extractive industry in terms of actually having legal and policy frameworks that are clearly outlined to safeguard the different genders. Because you find, for instance, in a study that shows that, for instance, in Tulo oil, within its the senior managers are women, which is less than within the institutional guidelines. So what are the effects of, what are the effects that, what is the impact that this does this have on the environment? There's a destruction of the habitat, which we are supposed to safeguard for posterity, for future generations. There's an increased amount of pollution and waste into the environment. There's a decrease in soil quality because mining and deforestation destabilizes soil and increases the aspect of soil erosion, reduces the nutrient levels within the soils, and the water quality is also affected. Because I've also touched on the aspect of water, there's a inaccessibility to fresh water. Because, for instance, within the East African region, we have Lake Victoria, which is a common feature to the three countries, Kenya, Uganda, and Tanzania. But because each country has its own regulations, they do not have a standard policy, standard legislation to guide. Then you find some of the within that ecosystem, there is the aspect of the food that we derive from that is negatively impacted, which also impacts on individuals' health, but also the physical features within that. We have there's some aspects of areas within that area that are sinking land, and which has caused fractures within the environment. Then there's also the aspect of increased seismic activity because of the drilling and the extractions that are done, which also has a negative effect on the human population growth and the accessibility to social amenities. Then also there's the aspect of climate change, since the use of extracted fossil fuels is a primary cause of current climate change, which alters the Earth's ecosystem and causing global human and environmental health problems. So what are the key challenges that are arising out of these identified factors? There's aspect of political instability, which also has a ripple effect on both the physical and the social environment. There's the aspect of the foreign exchange market, stock exchange market, which is negatively impacted because you may find instances where they have to be, there's the devaluation of the stock exchange. Then there's aspect of the tax environment also being impacted, which has also a ripple effect of having not only an impact on the individual country economy, but also on the business environment that is relied upon by those state parties as a source of income and as a source of development. Then there's the failure, the lack of an effective monitoring and regulatory framework for the management of the different industries. Then there's still a lack of transparent policy and legislative framework that can be used to manage the extractive industry. Then as we go on to the gender aspect of it, the East African countries are predominantly African. So the first thing that we look at on this is the issue of patriarchy and culture, which by and large impacts on how women are perceived. What is their contribution? Are they considered within the decision-making process? Are they included within processes, for instance, the extractive industry? Are they segmented because of their traditional gender roles as women, that they're relegated to be housewives, as opposed to be equal partners as envisioned in the sustainability development goals? There's the aspect of their physique, because of their menstruation, because of their general physique of giving birth. You find some of them are precluded from the decision-making processes. You find that there's a place of women in culture. Women are, by and large, segmented to traditional roles, basically to be the kitchen, not within what is perceived to be the boys' club. So they're not really included within the decision-making process. There's a consideration of their biological and their women's health, which is considered as a hindrance, because some people say there's a huge segment of them being impacted by their psychology, by their general makeup. They tend to be moody, they make decisions haphazardly, which is not the case. So you find, because of those traditional ideologies, some in certain segments of the economy and trade and investment, they've been relegated. So it is up to them to stretch out and actually prove their roles within the aspect of trade. So there's also the aspect of the engagement within the corporate sector. We have laws and regulations. I use Kenya, for example. We have the Mwongozo, which requires that at least 30% of women are considered within the corporate environment, but this is not strictly done. I used earlier the example of Tulo, where you find that at least 6 out of the 49 managers are women, which is way below the 30% threshold that had been set out. So it is up to them to push for them to get such roles. There's the aspect of they use what I call body in trade. For instance, for them to engage in roles or responsibilities such as extraction or mining, you find some of them pay their colleagues using sex to draw for them sand or other minerals, so that they can get their source of income, or also just justify their source of income. Then there's the aspect of the things that are happening within that particular environment. There's the aspect of gender-based violence, both for men and women. For women, in terms of them getting raped within certain segments of trade, such as the extractive sector, because it's the aspect of security. Not all of them, yes, they may have been qualified academically, but they do not have that physique or guard themselves. So you find that such elements expose them to insecurity, which you find at the end of it there. Recommendation we've identified. First of all is is for the demystification of international treaties and obligations that advocate for gender equality. And also just within the different sectors, there has to be the domestication of international treaties and laws. So for instance, within the mining sector, there's the law on mining, and I'm happy to say, for instance, in Tanzania, there's a Tanzanian Women Miners Association, which has aligned with the global legislation on extractive industry, and which is also a faceta with the rest of the Western and Southern African countries on how legislation on best practices and use of mining and incorporation of both genders within the mining industry. So there's the aspect of displacement and compensation.
Wind up.
There's the aspect of displacement and compensation in areas where people have been displaced. Then there has to be some level of compensation. There has to be review of there has to be incorporation, domestication of international treaties and obligations that advocate for sector-related industries that are positive to that particular environment. And then there's a creation of transparent policy and legislative framework on the management of different sectors of the economy. There has to be a review of both physical and national physical, foreign and national policies on investment and trade. And there has to be creation of a stable political environment. Thank you.
Thank you so much, Ms. Panja. And at the end is where we got you well. The network was a bit unstable, but we got the gist of the presentation. And as you ended, you spoke about the need to domesticate existing international treaties and also for states to comply with existing obligations. And that comes along with the next presentation from Mr. Joseph Byomuhangi, where just a brief of his bio, Mr. Joseph Byomuhangi leads the Business and Human Rights Program at the Initiative for Social and Economic Rights in Uganda. As one of his activities, he's also part of the African Coalition for Corporate Accountability, and he has been part of the advocacy for having an African voice in the development of the legally binding instruments to regulate activities of transnational cooperation in international human rights law. So Mr. Joseph will take us through the existing international, regional, and national frameworks on issues of business and human rights, but also he'll give us the best practice in EAC on the existing framework of BHR and provide us recommendation as a region what frameworks need to be adapted to promote cross-border trade and investment while ensuring that there is promotion of business and human rights in those activities. Welcome, Mr. Joseph.
Thank you, praise God. Good afternoon, colleagues. It's afternoon here in East Africa, but I understand we have colleagues from all over the globe. I'm going to pick it up from where praise God has left it. Let me try to share my screen such that we have the slides to guide my discussion. I'm going to speak to the international, regional, and national frameworks on the emerging challenges to consensus and coherence when it comes to business and human rights. And to sort of give a brief preamble, when we talk about business, it's a general assumption that everybody knows what business is. A business is any venture done to generate profit, really. It could be sale of a service or a product. And with the capitalistic economic order globally, this is something that we have been at for the past 50 years, and it intensified really And time came when we had that globalization with regards to business activity and the negative impacts that result from business activity then pushed the world to come up with frameworks to sort of provide a regulation that would be able to protect people, the planet, and all other stakeholders that are affected by business activity. So I won't be able to speak to the positive impacts of business activity, but just to go into the frameworks because they are the basis upon which best practices can be could be on the call to understand what needs to be done to be able to have sustainable business. So the discussions around the frameworks to govern issues of business and human rights with regard to a global consensus are anchored in the United Nations guiding principles with regards to respect for business and human rights. And the principles really have three pillars. The first pillar is the state duty to protect, which speaks to the obligation of the state to protect its citizens and the environment in which the citizens live, such that the adverse impacts of business activities do not affect them. The second pillar is the corporate responsibility to respect human rights, and this largely speaks to companies. Often at times, we have what they call corporate social responsibility, and most people tend to confuse corporate social responsibility with a corporate responsibility to respect human rights. But the clear distinction is that the second pillar of the United Nations Guiding Principles on Business and Human Rights speaks to the need for companies to respect human rights, starting with the individuals they employ as workers, to the communities that are hosting them, and all those in their value and supply chains. And then in the event that both the state and the companies fail to meet their expected obligation, there should be access to effective remedy for victims of corporate human rights abuses. So that's really the anchor of the international frameworks when it comes to issues of business and human rights, with those three pillars guiding conversations. At that level, for lawyers on the call, you'll understand that this falls under the realm of soft law. It's just a guide. And like the first panelist shared with us, there are some companies that have picked best practices from this guide. But then there is also a bulk of companies that have not picked best practices from the guide and are still waiting on for compelling legal frameworks to be able to match up with the required standard. Particularly for labor, the International Labour Organization conventions are quite numerous and they speak to the various aspects of what amounts to decent work. And it's of great importance for us to know that labor as a factor of production is very pivotal for the sustainability of running businesses. So the ILO conventions play a big role. I won't go into them because I don't have so much time, but summarily they speak to what should be decent work for people that are employed by these businesses. And that's a guide for us because most of our countries in the East African community have ratified them. Generally, from the international human rights law perspective, still most of our countries have ratified the international human rights law instruments, particularly the International Covenant on Social and Economic Rights, and the bulk of these issues also reflect there. When speaking to issues of international frameworks, I'd love to speak to what's currently happening in Brussels with the development of the European Union Corporate Sustainability Due Diligence Directive. By tomorrow, we'll know if the EU has chosen to pass this legal framework or not. And for us as colleagues in East Africa, it's of great importance to us because the bulk of our trade with the European Union will be impacted by this legal framework. It's something we welcome, and the reason why we welcome it is because it will have a ripple effect on business practices as we know them in our jurisdictions. For us to access the European Union market, we would then have to comply to the due diligence standard that has been set That's if they pass it tomorrow. But we hope they do, because it's of great importance for the purposes of saving the planet, because it anchors so much emphasis and focus on environmental protection, but also people, that's the host communities and people, our citizens that are employed by these companies. There shouldn't be traces of human rights corporate abuses that are linked to a particular company or its supply chains that trades in the European Union. So those are some of the focuses that we need to look at. The Corporate Sustainability Due Diligence Directive comes along with the forced labor regulation, and it also seeks to eliminate forced labor in the entire supply chain of a company to ensure that we do not have victims of servitude and slavery working in particular companies to be able to earn the shareholders a profit, but then put their lives at risk. Together with that deforestation regulation that also seeks to protect the environment, we should not have trees cut down, for example, to set up more coffee plantations. That coffee will not have access to the European Union market. So it's important for colleagues on the call, especially those that provide advisory services to the different enterprises in East Africa, to pay attention to such developments at the European Union level. In terms of what we aspire to internationally, we are pushing to have a legally binding instrument that regulates activities of transnational companies in international human rights law. Like I've discussed earlier on, what we have currently that is a global consensus is the UNGPs, the United Nations Guiding Principles on Business and Human Rights, and challenges that they are only but voluntary. So we are trying so much to develop a legally binding instrument, which would become hard law, to be able to regulate activities of transnational corporations in international human rights law, because international human rights law is agreed as a standard of protection for the rights of communities, workers, and the environment. So when we bring transnational corporations into the realm of international human rights law, we believe that that would be adequate regulation. So those are the developments happening at national framework, but I'll also speak to what's happening regionally, and that's at the African level. The African Union Agenda 2063 is a strategic framework that the African Union looks at using to deliver inclusive and sustainable development. And indeed, in that framework, there is emphasis on the importance of decent work and social security. All these have a link to issues of business and human rights. Because the priority areas of that framework speak to the kind of environment businesses need to thrive on the continent, but also ensuring that the workers are treated fairly, that is, they have decent work and enjoy their rights as workers. That's how we will be able to get value as a continent. It's an aspiration, and we hope that by 2063, if it happens in our lifetime, we're able to realize its aspirations. In terms of human rights, the African Charter on Human and People's Rights extensively elaborates the rights that we have as African citizens, and issues of business and human rights also tend to feature. I just wanted to make mention that just last year, the African Commission issued General Comment number 7 that explains the state obligations under the African Charter on Human and People's Rights in the context of private provision of social services. Colleagues on the call could wonder why this is of great importance to us. In East Africa, there is an increased number of private actors that have ventured into the provision of social services. And when we speak about social services, we are speaking about provision of education, provision of healthcare, among other social services. But then, under the international human rights law, education and healthcare are human rights. So this general comment offers that guidance on how best states are able to exercise their obligations to ensure that their citizens enjoy the rights that are guaranteed, for example, education and healthcare, and on the other hand, offer them guidance on how best to regulate the private actors that have come to venture into this space. It's a huge crisis. Most of us experienced the brunt of it at the peak of COVID-19, especially with healthcare. And the situation wasn't really good. In my country, Uganda, some families had to sell off their property to be able to get the bodies of their loved ones who had lost the battle to COVID-19. And that was primarily because the cost of healthcare was so high. When we looked onto our governments for solace, they were quick to tell us they did not have a regulatory framework because a private actor came on board. They were given a license, they set up a hospital. And so there was no intervention from the state at that level. Such experiences informed our development of the National Action Plan on Business and Human Rights, which I'll speak to when we get to the discussion of the national instruments. But I just wanted to emphasize that aspect because most times people tend to forget that these social services are actually social rights. They are human rights, and therefore the state has a core obligation of ensuring that every citizen enjoys them irrespective of their economic status. So it's one of the greatest areas we are pushing back against in the realm of business and human rights that impacts the common man. At the East African level, yes, our treaty has been mentioned of by the previous panelists. I particularly singled out Article 7.1a that critically centers the community's operational principles on people, and 2 enjoins the states to abide by principles of rule of law, social justice, and universally accepted standards of human rights, which lie central to business and human rights agenda. Everything that speaks to social justice, everything that speaks to placing people at the center is of great importance to the discourse of business and human rights because we are dealing with a delicate balance. On one hand, you have shareholders that have invested in a venture and expect a return on investment. So their focus is the profit margin. On the other side, you have the communities that are hosting these businesses. They have to give up their land, for example, for the business to set up. And you have workers that are there and they're supposed to have decent work. For them to have decent work, there is a cost that the company has to incur, that the business has to incur. So the management of these companies is always seated to balance the interests of the shareholders on one hand and to ensure that there is decent work for the people that they've employed, for the communities that are hosting them, and everyone is involved in the value and supply chain. So the discourse of business and human rights always has people at the center and the environment, because in cutting costs, we are often sacrificed as a people and the environment from which we derive our livelihood. So we need to pay so much attention to ensure that these frameworks are there and they are binding to ensure that under no circumstances, companies are cutting corners to be able to maximize profit for their shareholders and sacrifice us, the people on the planet. For national frameworks, the constitutions of the membership of the East African Community provide for a normative framework for the protection of human rights in all aspects, including the conduct of businesses. I'll start with my own country. Under our 1995 Constitution, we have a Bill of Rights and a Chapter 4. It's the same story with the 2010 Kenyan Constitution, and still the Bill of Rights is reflected in the constitutions for the Republic of Tanzania, Rwanda, Burundi, and the other member states that are part of the East African Community. But when it comes to issues of business and human rights, on the African continent, Kenya was the first country to domesticate the United Nations guiding principles on business and human rights. I hope colleagues still remember those 3 pillars. And subsequently, Uganda followed. And so we've taken lead on the continent when it comes to domestication of the United Nations guiding principles on business and human rights. Currently, there are about 15 other African countries in West Africa and Southern Africa that are trying to domesticate the UNGPs by developing their own national action plans on business and human rights. It's a good step to have a policy document at national level that speaks to this subject, because for us, I'll use the example of Uganda. One of the wins we've been able to get with this policy document is the shift in mindset of our policymakers and duty bearers in terms of accepting that you can have a conversation about business and human rights in one sentence. Previously, the head of state of Uganda has been attracting investors, and this is something he continuously does. Today is the last day of the Uganda European Union Business Forum, and he was there yesterday, still calling on people to come and invest in the country. But the challenge has been that we stop at attracting investors and selling what we can offer for them to come and attract in our destination countries. We don't go ahead to have a robust legal framework that stipulates what responsible business conduct should be. Now, when you get an investor that is not cognizant of the human rights concerns, they'll focus on maximizing profit for their shareholders and sacrifice everything, including human rights of the people they employ, the communities hosting them, and all of us in their value and supply chains. That's where challenges of consumer protection will emerge, because you'll find substandard products on the market, because in that factory, they were thinking of minimizing the cost of production. So they make counterfeit products and put them out there without having standard setting agencies and regulatory bodies strictly following up what is being done by these businesses. The battle would be lost, because they'll always choose profit over us. So the national action plans are always context-based. They look at the major challenges in the realm of business and human rights for the countries and provide a coordination framework for all stakeholders to be able to ensure that there is responsible business conduct. It's something that other countries are picking up. I know that Tanzania is at the stage of conducting a baseline assessment, such that they're able to use it to inform the development of their national action plan on business and human rights. But nationally, we also have subsidiary legislations, the various legal frameworks that speak to labor and employment relations, environmental protection. Just recently, our Occupational Safety and Health Act in Uganda was being reviewed to bring it up to date to the new trends with regards to occupational safety and health at the place of work. It was a legislation that was developed in 2006, and certainly between now in 2024 and 2006, very many aspects of occupational safety have changed, and so it's due for review. But such subsidiary legislations speak to issues of how best we should ensure that there is regulation of business activity to minimize the negative impacts that could result into hurting the people and the planet. There are some challenges that are existent in the framework. Discussing, most of it has been manifested, that the national action plans that are domesticating the UN guiding principles on business and human rights are all voluntary, and there isn't anything binding to compel companies to ensure that they do their business as per the set standard. It's just that as a guide, there'll be those companies that will pick it up and are able to adhere to the guide and have best practices. And in the work that we do, we encourage those companies to share their best practices, such that other boardrooms are also able to draw from their best practices and ensure that they adhere to the standards. There are challenges in protecting the vulnerable groups, especially communities, because most of the investments that happen in our part of the world are happening on land, and we do not have land that is bare. People are doing something on the land. So that means there is a group of people that have to be evicted to pave way for an investment. How do we protect those vulnerable groups to ensure that they are relocated or resettled in a dignified manner as citizens of our countries? The greatest challenge we have as colleagues on the call is the issue of access to remedy. As people practicing in the various jurisdictions of the East African community, you certainly have observed challenges of our judicial system in terms of offering effective remedies. So I won't belabor in explaining that. Thank you, but I just wanted to speak briefly on issues of access to remedy. Praise God, if you could allow me to to conclude with that.
Thank you, but I will put a hold on that. So
Okay.
that means Joyce Komanya can start on that particular end where you have ended on issues of remedies so that you can pick up from that.
Okay, thank you.
Thank you very much, Mr. Joseph. And as you have likely ended, and as I have said, Ms. Joyce will come up and speak about the issues of remedies and the issues of existing mechanism, both regional and also national-wise, that can be used on those who have faced risks arising from activities from different business sectors. To introduce Ms. Joyce, she's the Senior Program Officer on Corporate Accountability at Legal and Human Rights Center. And through her expertise in research and analytical writing, she has championed for the Tanzanian Human Rights Report of 2018 and the Human Rights and Business Report of 2017. Ms. Joyce has 5 years experience in leading with grievance mechanism on access to remedy, judicial and non-judicial mechanism. I'll welcome Ms. Joyce to take us through a discussion on the existing redress mechanism in EAC, but also as Africa in general and at the existing international mechanism. Welcome, Ms. Joyce.
Thank you. Hello?
We
I
can
hope
hear
you
you,
can-
Ms. Joyce. Yes.
All right. All right. As I will introduce, my name is Joyce, and I'm going to talk about the redress mechanisms for human rights violation, for violations that are emanating from business operations, specifically in the country, which are most likely similar that are happening in the rest of East Africa and the African continent. And my fellow speaker was also he gave us an overview of the UN guiding principles on business and human rights, as we are aware that the foundational principles are laid upon the principles on the document of the governing the as it was developed by the Human Rights Council on the United Nations guiding principles on business and human rights of 2011. And this the document, these principles are specifically divided into 3 pillars that each categorical are providing the responsibilities upon each group on how best can protect and promote human rights and can also offer remedies to the victims of business operation in such areas. As we are aware that the guideline principles has provided responsibility, has conferred responsibility upon states to ensure that they offer protection on a human rights issue, such that with regards to availability of the laws, regulations, and policies that will govern issues of business operations, while on the other side, consider complying and being held these violators accountable in case human rights issues are violated by the business operator. So specifically, states are mandated to ensure that the laws, or the available laws, or if needs be, there is an amendment of the law so as to ensure that investments, while there's investment progress in the country, the economic progress in the country, but also human rights issues are well complied with by these business people. But also, as I have said, that the UN guiding principle, the foundation of that, it speaks of the principles that are supposed to be followed when business and human rights issues are then we have the second principle that lies upon the corporates or lies upon business operators to ensure that they respect the human rights standards. And by respecting human rights standards, that means these are operations of the business has to ensure that they comply and they respect the international convention, but they also respect the national laws and policies governing the operations in given countries. So by compliance, that means they have to conduct their businesses in a way that they ensure there is responsible business conduct and the issues of corporate social responsibility are well complied with. That is the second responsibility. So states have to ensure that they comply and they respect whatever laws that are governing the operation in such country, starting from the constitution of a given country, coming to the other laws that are governing the operation, being the labor laws, the land law, investment laws, environment laws, and other laws in that area. And also we have the third pillar that I'm going to talk about, that it speaks of the access to remedy. But the access to remedy, this is the third pillar where in case of that, the government has offered protection to its people with regards to operation of business in the country. But then the corporates or the business operators have failed to comply with the human rights standard, to comply with the national and international standards governing the operation. Then in case of violations, these aggrieved communities or aggrieved individuals need to have mechanisms where they can be able to access their remedies for whatever that has been violated by operation of such businesses. Not only the surrounding communities, but whoever has in contact with the operation of this business and have been violated or aggrieved by the operation in terms of any sort of issue, especially some with issues regarding to labor, land, environment, and other issues as well, then should be able to have to access a mechanism that is favorable to them, so that they can file grievances and the situation can be remediated by the business operators. As I've mentioned that we have the UN guiding principles is the foundation of the operation of businesses in terms of how best they can comply and how states can make these business operators accountable in case of violation of human rights during the operation. But also the guiding principles works along with other documents as well. It doesn't stand alone because this document is non-enforceable. So it has to depend on other documents and other laws, such as the constitution of the country, but also the national law and the international conventions, such as the African Charter on Human and People's Rights, but also the charter establishing the operation of the East African Community. We also have the Constitution of the United, for example, we rely on the Constitution of the United Republic of Tanzania, but we also have the national laws and regulation as well as policies that are governing operation of businesses in the country. And when it comes to redress mechanism, which is the third pillar of the guiding principles on business and human rights, when it comes to redress mechanism, we speak of making good that in case there's any human rights harm that has occurred due to business operation, then that means these business operators have to make good of any harm that is caused by them or it is likely to be caused by them. They have to ensure that they remediate and restore the aggrieved community's right to enjoyment of the permanent natural resources. They have also to make sure that they prevent whatever harm that can happen, be it through injunctions, or they can also be a non-repetition order provided to them to ensure that these remedies or the redress of their situation is being done by these companies. But also specifically, these remedy mechanisms are meant to ensure that there is protection of individuals from harms caused by business operation. These some of the remedies that when people are, when the individuals are claiming for the violation of human rights in the business area, the guiding principles provide for some mechanism, for some remedy that can be as a substitute of redressing the situation or remediating situation of the aggrieved community. And it was able to mention some of the things such as it could be through apologies, restitution, rehabilitation, financial or non-financial compensation, and punitive sanction as well are also mentioned by the UN guiding principle as part of the redress mechanism. But also, When it comes to redress mechanism, also the principles have also underlined, has provided on specific, not specifical person, but who can also file for this, who can file or can question and can seek assistance from the state to ensure that the business operators are redressing the situation. And this can be initiated by individuals, the aggrieved persons themselves, but also the relatives of the aggrieved person. The civil society organization can also file for or make follow-up on the situation and ensure that the business operators are redressing the situation, but also through non-state-based judicial mechanism where the authority responsible in offering the state-based non-judicial mechanism can also initiate these issues to ensure that the aggrieved communities are assisted to access their justices from the business operators. For the case of Tanzania, but East Africa in general, as I mentioned, that we rely on the document, and the document has explicitly provided for 3 possible mechanisms that can be able to be accessed to ensure that the situation of these aggrieved communities can be remediated or can offer as the redress mechanism in case of violation of human rights by the business operators. So we have the mechanism operated by the state and those that are initiated by the company themselves. The mechanism that are operated by state, we have the state-based judicial mechanism, and we also have the state-based non-judicial mechanism. And for the mechanism that are operated or are initiated by the companies, we also have the independent grievance mechanism. Sometimes we also have others also prefer, or they can also mention the presence of the traditional mechanism, but they are not in real sense applicable when it comes to issues of redressing situation of aggrieved person due to business operation. So as for the state-based judicial mechanism, we can speak of the hierarchy system of the judicial. That means whatever system that is available in a country to provide with the judicial decisions, then can be able to be accessed to ensure that the victims of business operation are remediated based on the issues that have been raised by such kind of people. So with the judicial grievance mechanism, then we have the courts of law, starting from the district court, but we also have the high court, and then we have the court of appeal. So for the case of Tanzania, then we have the district court, we have the high court, and then we have the court of appeal of the United Republic of Tanzania. These are the available mechanisms that can redress situation of individuals whose rights have been infringed by the operation of business in the country. And by accessing the remedies through the state-based judicial mechanism, that means they have to undergo all the necessary procedures that require them to file suit into such cases. So it is procedural as other cases are being filed to such courts, just like any other cases that are filed to such judicial mechanisms. And when you speak of the state-based non-judicial mechanism, these are the mechanisms that are state-based. They specifically operate under certain law, and they have given a mandate and a specific law that establishes them to ensure that they also redress and they assist in ensuring that the aggrieved individuals whose rights have been violated by operation of business are being assisted to ensure that remedies are available to them. And specifically for the case of Tanzania, we have the Commission for Human Rights and Good Governance that is given a mandate to ensure that it offers assistance through the state-based non-judicial mechanism and ensure that the victims of business operations are being assisted to are being assisted to be remediated of the given situation. But then we have the Mining Commission for the case of extractive industry. The Mining Commission is also mandated to ensure that all issues that are emanating from the operation of extractive, operation of mining sectors, it offers a forum for these people to be able to access the commission, and raise their grievances and ensure that they offer protection to these people through the state-based non-judicial mechanism. But we also have some of the regulatory authorities that also have these powers to ensure that the operators and violators of human rights that are emanating from the business operation are also held accountable through some measures such as such as fines, payment, and other measures as well. A very good example is we have the National Environment Management Council name that is given a mandate to ensure that all issues pertaining to environmental protection and environmental degradation, they have a mandate to oversee such incidents, and they can also offer punitive sanctions such as fines and other sanction as well to ensure that business operators comply with the international standards of human rights, national and other policies that are offering for protection of environmental rights in the country. And when it comes to non-state-based judicial grievance mechanism, these are independent grievance mechanisms that are initiated by the companies themselves. And as I've said that we have a challenge of operation of the UN Guiding Principles on Business and Human Rights because it is a non-enforceable sort. All the principles are not compelling these business operators to abide with whatever that has been provided by the principle. So it is sort of offering guidance so that they can be able to conduct their business or they operate their business while they align their operation with the underlying principles as provided by the document. So that means this mechanism, this kind of a mechanism, the independent grievance mechanism, is usually provided by companies where they just want to have such a mechanism. So there is no law that is compelling them to have this mechanism. They just have to adhere with this based on the kind of maybe the nature of incidents that they are experiencing that are being reported to them by the surrounding communities, or in case of several issues that are with excessiveness of legal cases and other issues that is compelling them to have this mechanism so as to reduce the number of cases or to reduce the number of people that are opting for the judicial grievance mechanism. But I was also, and the most common grievances that are being filed through these be it judicial or non-judicial mechanism are usually emanating from land issues, especially with the expansion of business operations, such as expansion of the big mining companies in areas where there is mining activities, but also labor issues with regard to violation of labor standards, but also non-compliance with the laws governing occupational safety and health safety acts. But also we have experienced a lot of protection and environmental degradation cases that are also filed to these mechanisms to ensure that the business operators are complying with environmental standards and the protecting environment of the surrounding community. But also there are incidents of killings of civilians by security forces, especially in the extractive area. These are also some kind of cases that are much well experienced, especially in extractive areas, and they are also taken into these kind of mechanisms for states to protect these civilians against operation of this business. I was also asked to discuss about the successful mechanisms.
Joyce, please wind up so that we can also discussion with participants.
Okay, I'm winding up. And among the successful mechanism based on the experiences on the nature of the incidents and the kind of people that we're working with, the successful mechanisms lies under the non-judicial mechanism, be it the non-state-based judicial mechanism or the non-state-based non-judicial mechanism. That means the state-based non-judicial, as I mentioned, non-judicial grievance mechanism and the non-state-based non-judicial mechanism, such as the independent grievance mechanism that are initiated by the company. And these are successful because of the underlying principle number 31 that is provided by the UN Guiding Principle on business and human rights. Because most of the time they are legitimate, there is trust from these people on the kind of mechanism that they are engaging, rather than they would opt for the non-judicial mechanism rather than going straight to the judicial mechanism because they have trust in them. But also the accessibility of this kind of mechanism. It's easy, you know, most of the community members are afraid to go through the judicial procedures, so they would rather opt for the non-judicial based mechanism. Then it's very easy for them to access this mechanism rather than going to court and follow the judicial processes. But also they are predictable because they are clear most of the time. The procedures are known, and there is clarity on the process. And sometimes the time frame of these cases are also mentioned to the victim. They are equitable and they're also transparent because sufficient information about the mechanism and its performance is also provided to the victim. It is also rights compatible because it also aligns with the international human rights standards. And okay, I'm ending up with the last question that required me to on how we, as a East African Court of Justice, we can be able to act as a redress mechanism, because we have the capacity of individuals to file cases against states if at all they fail to protect human rights. They fail to protect individuals from human rights violation. That means individuals can be able to file cases against their own states with regard to these states being unable to hold accountable these operations that are harming, these operations that are non-complying with the international human rights standard, but also the national law. That means the East Africa Court of Justice can also be used to ensure that individuals are able to file claims against their own state whenever their rights are infringed and these states are not taking up any action to assist or to offer protection of such people, so that the court can be able to offer the interim measures or urgent action to ensure that the business operators are refraining from whatever activities that are harming these community members. And that makes the end of my presentation. Thank you.
Thank you so much, Ms. Joyce, and thank you all panelists for the broad presentation. And now I'll welcome participants with comments, contribution, and also questions in reference to the wide area the panelists have spoken about. I will look for a raised hand from participants so that I can allow you to speak. As we are waiting for a show of hands, there's a question from Sandra. She says, what is the advice that can be given to a legal professional who seeks to pursue a career in business and human rights after specializing in studying in their master's degree. There's that question. I'll take a few, but since I'm the moderator, I'll also raise a question to the panelists, but also the participants. As the last speaker spoke about how the non-judicial mechanism are the best means to ensure redress to victims of human rights violation by business sectors. The issue arises, how effective are these mechanisms and how many people are willing to go to this mechanism? Because knowing about the African system, most of our national mechanisms are corrupt, to say. So how effective or how willing will the victims be ready to access this non-judicial mechanism? I will pose the question to Ms. Joyce, but also the other speakers can give a contribution on that. And another question from Ms. Catherine. She's requesting the presenters to point some of the domestic and international companies that are a best practice for human rights due diligence and the issues of access to remedies. Okay, I had said I'll take 3 questions, but let me take the 4th one from Frida. The question is on the transnational companies usually have IMS. What are the non-judicial mechanisms can we explore for the local companies? I welcome the panelists can just unmute and speak.
Hello. I wish to respond on the question that was raised to me, and that was regarding to how effective are the non-judicial mechanisms based on the national mechanisms that are available. And as I've mentioned that usually the judicial mechanisms are effective, but based on based on the experiences and the kind of cases that have been engaging from the community member, they, especially with the literacy level, that these people prefer the national based, the non-judicial mechanism because of I think it's because of the procedures, but also because of the time frame of these cases and, lack of knowledge on the legal procedure, that the people would prefer to go to the non-judicial mechanism because they're accessible to them than the judicial mechanism. So the effectiveness is based on how people perceive the kind of mechanism that are available to them because of the procedure and the long time that maybe cases are, the time that the cases are taken to be adjudicated in judicial forum. So they would rather prefer for that judicial mechanism. And sometimes they would rather prefer for non-state-based non-judicial mechanism because they would find that they're also available and accessible within the vicinities of where these people reside. That has been the main reason of why these people are preferring the non-judicial mechanism.
Thank you, Joyce. I welcome Mr. Joseph to contribute to the other question and also if he has an additional response to that.
Thank you so much, moderator. I hope I can be heard audibly. I just wanted to add on to the non-judicial mechanisms when you cut me short, that sometimes the best option is to also use development finance institutions to see to it that you utilize their independent accountability mechanisms for some of the abuses that could result from business activities interacting with communities and the people they employ. I don't know which other questions have been directed to me. I missed hearing them, maybe. Moderator, kindly share with me the questions that have asked to me.
All right, the questions were shared on the chat. Let me repeat the question that you can respond. There was a question about to point out how some of the domestic or international companies that are best practice on cases for human rights due diligence and the issues of access to remedy. And the other question was the transnational companies usually have IMS. What non-judicial mechanism can we explore for the local companies? And the last question involves what will be your message to the EU policy and decision makers considering the current COREPA negotiation that are likely to compromise the original text? And do you see any other gaps in other BHR related EU legislations?
Thank you so much. I'll start with the first question in terms of some of the companies that we've seen with best practices. The colleagues in Kenya will correct me if I'm wrong, but from where I sit, I think Diageo has best practices when it comes to human rights due diligence in their entire supply chain. So it's one of the companies we encourage to popularize the best practices here in East Africa for other companies to draw lessons and inspiration from. Then the other question was what we are seeing with regards to the negotiations of the Corporate Sustainability Due Diligence Directive that is currently ongoing. We hope that they do not kill the legal framework. We hope that by tomorrow we'll have the legal framework. It's true, there'll be concessions on aspects of probably scope, legal liability, and various issues of value chain, and the focus would be limited perhaps to direct relationships. They may raise the threshold with regards to the target of companies. But my message is we need to have that Corporate Sustainability Due Diligence Directive. Then as regards to the gaps that would arise from what the agreed text may turn out to be, those we will have to fix by encouraging companies to adopt them as best practice, but at least the existence of the 3D would serve as a starting point to engage and have a regulatory framework that guides to what companies should do when it comes to human rights due diligence. That is mandatory beyond the voluntary measures that we have in our guiding principles on business and human rights that are being domesticated in national action plans on business and human rights. The other gaps that we see with regards to the business and human rights EU-related legislation, there has to be a lot of awareness raising because majority of our policymakers do not know what is going on at the EU. They do not even anticipate the impact it will have on our trade relations, and also the companies and players in the supply chains are worried who is going to bear the cost of ensuring that there is compliance. Do we have adequate legal framework, for example, to support traceability? And those are key components in the legal frameworks that are happening in the EU. So what would implore is for all stakeholders, starting with the East African Law Society and the various ABA members available on the call from the East African community, is to interest yourselves in those pieces of legislation, get to identify what they are asking for, and contribute in one way or another by disseminating information to whoever you can reach, be they policymakers, be they companies in your advisory, and also those that are in civil society that are working with communities. You need to also disseminate this information such that we are able to now push for their implementation, because in as much as ignorance of the law is no defense, we need to do a lot of work and work together to bridge that ignorance. It's what I see that is a major gap for all of us, and we have to rise to the occasion to bridge it. Thank you. I don't know if I left any other question unanswered. In case it's there, please flag it for me.
All right, thank you so much, Joseph, for your response. I'll welcome Dr. Jessica to also respond on the best practice. The question where if she can point out existing domestic or international companies that are best practice cases for human rights due diligence?
Thank you, Grace, for that question. So I would say in Tanzania, we have a few case studies, although local companies are still catching up, but I will point out a few of the companies, such as we have the Coca-Cola, both the Nyanza Bottling and the Coca-Cola main company. Yeah. And apart from that, we have the multinational companies.
Thank you, Dr. Jessica. All right, I can see a comment from Mr. Leroy Wilson, where he specifically directed it to Mr. Joseph that you left out comments on the issues of corruption in non-judicial mechanism.
Thank you so much, Wilson, for flagging that. Corruption is a major challenge to access to effective remedy, be it in the judicial, quasi-judicial, and non-judicial mechanisms. And so we have to work so hard to ensure that the victims of corporate human rights abuses are aware about the procedure, particularly now for the non-judicial mechanisms. They need to be knowledgeable on the procedure, because the moment they are ignorant about the procedure, then they become victims of the corrupt tendencies that the different facilitators involved in the judicial mechanisms have. So as colleagues that could be on the call that sit on the other side of the judicial, quasi-judicial, we need to make sure we disseminate information with regard to the procedure. Because when a victim knows the procedure, it's very hard for them to become susceptible to corrupt tendencies. That's what I can recommend as best practice going forward for us to change the terrible tendencies of corruption across the access to remedy mechanisms.
Thank you so much, Mr. Joseph. And looking at also the question on best practice as commented with one of the participants, one other example is Safaricom in Kenya on issues of human rights, as asked by the participants. And looking now, I can welcome, if there's no any other question, I will welcome the panelists to do a round of winding up, final recommendation and conclusions. And I'll start with Mr. Joseph, since you're the last one to speak.
Okay, thank you so much. Praise God for the opportunity that you've given us to be able to contribute to this conversation. And I hope it has been a learning experience. On my part, I've learned a lot from colleagues that are coming from the corporate sector and I hope that it's going to change the way we approach things, because I'm largely currently doing a lot of work with civil society, and most times, both on the part of government and companies, they think we are antagonistic, and yet working together, I think, will best enable us to contribute to responsible business conduct, which we aspire, because on one hand, the people on the planet would be saved, but on the other hand, the businesses will run in a sustainable manner. So I'm grateful to the East African Law Society for having created this platform of engagement. whereby colleagues from the various sectors are able to come in and have a dialogue about issues of business and human rights. And we look forward to more engagements of a similar nature, such that we grow as a community and boost our trade and investment opportunities across board. Thank you.
Thank you so much, Joseph. I welcome Dr. Jessica.
Thank you very much, Praise. My concluding remarks would be for sort of businesses, policymakers to really keep on assessing the current policies in place, but also learning from best practices that are available in the industry. Because yes, as many companies adopt into best practices, which are currently being followed, however, there still needs more still needs to be done in as I explained before, in sectors such as the mining sector. Really, a lot there still needs to be done, because that's where we keep seeing issues coming up again and again, and in terms of the manufacturing sector as well. So that as a community, we all have our laws that are in line with each other and are for all companies. So thank you to everyone who attended today, and thank you very much to the East Africa Law Society for inviting me as a panelist here today. Thank you.
Thank you, Jessica. I welcome Ms. Joyce.
Hello. I would really wish to remind and to remind especially the corporate world that they should consider complying with human rights while during the operation of their business. They do not necessarily have to take compliance with human rights issues as a negative task to be undertaken to them, or it is among the way that it can never minimize the profit that they're getting from the business operations or from their business. So they should consider complying with the human rights standard, because at the end of the day, it will also reduce the kind of violations that are raised against the operations, but it will assist them in obtaining them with a social license to operate, because they will have a friendly way of operating, and they will have a positive impact and positive interaction, especially with the community surrounding them. Thank you.
Thank you, Joyce. I welcome Ms. Panja.
Thank you very much for everybody who was able to attend. My sincere apologies that there was an interruption in my network. I only realized it much later. But there's a recording of the entire session on YouTube if you need to access and to review what was presented. But the business and human rights segment is a growing area. There's a question that somebody had asked, Sandra Rugaita, if what would somebody need to do to pursue a career in business and human rights, and especially after specializing into the master's degree. I don't think I've found any local university within that's just focused on that, but you can review your local university and explore. It's a growing area for somebody who is interested within the corporate environment, and also finding a synergy between that and the human rights. Otherwise, a big thanks to every single person who's contributed, whether you attended, whether you're a presenter, and most importantly to the East Africa Law Society for giving us this platform. We hope that you'll join us again next month for another session, another topic that will keep you updated on the trends and developments within the PHR sector. Thank you.
Thank you so much, Ms. Banja. And Ms. Banja is the Vice Chair of the Business and Human Rights Committee in East African Law Society. I'll take this opportunity to thank everyone for taking part in this webinar. And like Banja said, we welcome you in the next upcoming webinars. And it will be good to continue learning, as this is a growing area on issues of business and human rights. Different resources are providing for different overview around the issue, and it is good to always be updated on the upcomings or the development in the issues of BHR. And one of the areas that we can use is our national law resources or law journals, where we can access issues of business and human rights, and also the African sources such as Africanly and the rest, but also the East African Law Society through their rule of law journals that they publish each year provides articles. And one of the areas that different authors provide speaks about issues of business and human rights. Thank you everyone for taking part, and thank you panelists for your good presentation around the area. Thank you everyone.